Welcome to Law Potato, Hot Legal Topics with Idaho Values.
Hey everyone, welcome into an all-new episode of Law Potato, Hot Legal Topics with Idaho Values. I am your host, Mike Leon. Today, I'm joined by Alan Harrison of Alan Harrison Law, along with Tim Sopalski, the firm's Director of Business Development. Alan has been focusing on helping Idaho families plan for the future with clarity and confidence, and Tim brings deep experience in estate planning, trust, and long-term legacy planning. Today's episode, we're going to be breaking down wills versus trust and how to think about which option fits you best. Gents, it's good to see you as always. Tim, I want to start with you. This is your first time here on the program, so a little intro to the audience out there. Share a little bit about not only your background, what drew you into this line of work with respect to estate planning and trust.
Well, first off, thanks for having us, Mike. We enjoy having the opportunity to share with the community we serve and the people in Idaho about why we're passionate behind estate planning. So for me, the reason I got into estate planning was actually skipping church, Sunday school. Interesting enough, I was in the hall of church and some guy approached me and started talking to me a little about what he did for a living. And he happened to run a trust department. And so beginning to talk with him about that got me into the perspective of what does that look like, and started learning about trust and just happened to stumble upon what trusts were. What I learned from that experience was that, people grow differently and you have different experiences. My life with my family, I've lost both my parents, and going through that personally, it's been a little bit of a eye-opening aspect of, were they prepared enough and how do we prepare? And so that's what I love about doing estate planning, is helping families stay together and not having the unpreparedness that allows for open arguments, essentially. So that's what I love about estate planning and being involved, is making sure that families actually stay together and they don't end up in legal battles and arguments.
Yeah. Well, sorry to hear about your parents, but I would echo the Lord works in mysterious ways. So that's what got you into this profession. So that is great to hear. Alan, let me ask you, because I mentioned in the intro and Tim mentioned a little bit there about, wills and trust, right? And our families prepared. So when people are deciding between a will and a trust, give them the core differences between the two that's most helpful for them to understand kind of right away.
Sure. Thanks for having us, Mike. Yeah, the biggest difference between a will and a trust is that a will, both of them designate where assets go. But with a will, if you have real estate or assets over $100,000, you actually have to go to the court to get permission to be able to distribute those assets. And the court will issue an order appointing the personal representative. And until they get that order, they really can't take action. They've got to wait for that. Whereas at the trust, you actually put assets into the trust. And once they're in the trust, then you're able to just take action and move forward. And Tim, he does a lot of our first contact with the clients. He's got a great analogy, and I'll go ahead and let him kind of give that analogy for us.
Well, let's hear it, Tim. Don't. I want to hear this analogy.
Yeah, so I look at estate planning as it's a vehicle to transfer your assets to the next generation or the beneficiaries you name. And so when I think of vehicles and I think of moving and transferring, I think of a moving truck, right? And so the analogy, I call it the moving truck analogy. Basically, if you were to die tomorrow and there's a moving truck outside your house, if it's a will, then what happens is everything that you own, your house, your financial accounts, typically it's in your personal name, it's going to go in the back of that moving truck. It'll get locked up. The person you name as personal representative, also known as executor, will go to the court to essentially get permission to have keys to the moving truck. Once they have the keys to the moving truck, they can get in the moving truck. They can start driving down the road, but they can't go too far because they're going to have to stop at a truck stop called probate. And that's at the same courthouse they were appointed. And so when they go through probate in Idaho, it typically takes about 4 to 6 months, depending on the complexity of the assets and the dynamic of the families. Once the probate is completed, then that personal representative can get back in the truck, drive down the road, and deliver the assets to the beneficiaries. So that's a moving truck for a will. if that moving truck was a trust, and that's the vehicle you chose to use for your estate planning, it's slightly different. The person you name as trustee already has the keys to that moving truck. So they can get into the truck, they can drive down the road, there's no truck stop to stop at, and they can just go deliver the assets to the beneficiaries. So essentially, when you pass from an administrative perspective, that's really the difference between the two.
Yeah. Tim, let me ask you, kind of staying on that, is there ever a time, or does it depend on each situation, where a will does make more sense than a trust, or a trust makes more sense than a will, given your analogy there, or is it very individual case specific?
Yeah, so it is several factors involved in each individual case that you want to go through and determine, okay, what assets do they have and what are the complexity of those assets? You're going to look at the family dynamic. Is there some contention in the family, or do we feel like everyone's going to get along? Is this going to be an easy process? And probate isn't too bad in Idaho compared to other states. It's actually a pretty simple process in Idaho. For me, it's just whether or not I want to have the benefit of the trust. And that would be, do I want to go through the court process? Do I want the court to oversee, my assets? Not that they get to dictate how they go, but do I want to really respond to the court or even go through that process? That's the question. And so if I want the privacy of a trust, if I want to prevent the court overseeing it, then I go that route of doing the trust. If I want the court to sign off on it because maybe my kids are a little contentious, or maybe there's some liability concerns I might have, then I may want the court to actually supervise more heavily in that probate and actually oversee the asset transfer. So there's just different factors that can get involved on that.
Yeah. Alan, speaking of the privacy front, because my understanding is, and you can correct me if I'm wrong, probate is a public process. Technically, people can go to that across different states. You tell me if it's different in Idaho. But how have you guys seen factors like privacy, like Tim mentioned, or maybe even control during incapacity, the ease for loved ones after death? Like, how does that all play into someone's decision when they're deciding?
Yeah, so a will is a public record. To submit the petition and submit the will, or if there's no will, just going through the court process to get a personal representative appointed, it's public record, and people can request that. Uh, with trust, there are a lot more private because you have assets in the trust. As long as those assets in the trust and you're not having to go through the court system, then the trustees are able to gather those assets, pay debts, and distribute them without filing anything with the court. And it does not become public record. And I guess I just would like to kind of go off a little bit more with when we kind of lean towards trust as opposed to a will. If we have property outside of the state, then we're always recommending a trust, because if you own property personally, let's say you own some in Idaho and some in Florida, you would have to probate in Idaho, and then you'd have to do, most states have what's called the ancillary probate, where you just take your Idaho order and you give it to the Florida court, and then you would have authority to act in Florida. But essentially, you'd end up having to probate in two places. Whereas if you have a trust, the trustee steps in, able to distribute the assets in Idaho as well as in Florida. Other situations we see is a lot of times on second marriages, where you have stepchildren and you want to make sure that the surviving spouse has a right to continue to live in the home. You designate how the fees are going to be paid for that, and then you clearly designate what's going to happen once that survivor dies. And a trust is just a lot better vehicle for that. Also with minor children, if you're wanting to continue to hold the home and allow guardians to live in that home and take care of them, once again, we're leaning towards the trust, just so that you don't have to transfer that home after someone's passed away. So those are some of the reasons that we look at trusts as better vehicles to be able to distribute the assets. They're not as public. Yeah.
Right. Well, Tim, let me piggyback on something Alan said there, because, obviously you're having conversations with people that come into the firm. I'm sure they have some preconceived notions or assumptions that they make about the debate between a will versus a trust. How do you guys kind of broach that and kind of explain to them and break down their assumptions of how these tools actually work in real life?
Yeah, so the major assumption that we receive is that a will does not go through probate. Everyone thinks that if I do at least some form of estate plan, then it avoids probate. And they think of probate as it's going to be the court steps in and dictates how my assets are to be distributed, when that's not the case. So the only way to prevent probate is to do a trust. There's other account tools that you can use, like a paid on death or a transfer on death, that will also prevent probate. Naming beneficiaries on financial accounts can prevent probate. Doing a community property with rights of survivorship on the title of a house can prevent probate when you're looking at a spouse situation. There's things that you can do to prevent the probate, again, using tools similar to a probate, small state affidavit being one of those as well. But for the most part, if you have assets, if you have a house and you're wanting to prevent probate, the trust is the way to do that. So the
Yeah.
will does not prevent probate. The will just dictates to the court how you want your assets to be transferred. And so that's really the biggest one for people. The other one I would say is that it automatically transfers to the spouse when the first spouse dies. That's actually not accurate in Idaho. Idaho is a community property state. And so the house, if it is a community property asset, if it was purchased during their marriage, they're both on the deed, it's going to look at it as a 50-50 ownership. So the challenge you have with that is when the first spouse dies, and let's say 3 years later, the second spouse decides, I'm going to sell the home and I need to consolidate, make it a little bit smaller. They then go to sell the home. Well, they have to go through probate because they have to remove the first spouse interest, that 50% interest they have, off of the home. So that's a big miscommunication for a lot of people, is it doesn't automatically transfer to the surviving spouse. You still have to handle their interest in the community property. The other thing is when you have second marriages, things like that, if you don't have an estate plan, you some people think it automatically defaults to the spouse, but it also depends on whether or not it's separate property or community property. Separate property has different intestate laws than community property. So intentionally, you could think, well, I'm not going to do anything. Everything's going to go to my spouse. If she's your second spouse and you have separate property, you could actually only have half of it going to that spouse and the other half going to your
Mm.
children, just by default in the state statute. So we have to be careful about those things. So I'd say those are probably the three main misconceptions we hear.
Alan, let me ask you, because Tim mentioned a few times there about death, but there is also when somebody's incapacitated, and I kind of alluded to it earlier. How does planning for incapacity during someone's lifetime kind of change the way you have these conversations with folks about whether a trust should be a part of the plan or whether they should go with a will?
Yeah, great question, Mike. So, in all of the plans that we do financial power of attorneys, medical power of attorneys, and then also a HIPAA release that allows them to talk to the doctors. And so, and that's in all of the plans. And the financial power of attorney gives an individual the ability to make decisions with regards to someone's finances that are outside of a trust. If they're inside of the trust, then the successor trustee would be the one to be able to make those decisions. And we have found that banks are, if you have an account at a bank and it's in the trust, a successor trustee has easier access to that money if someone becomes incapacitated than if they're using a power of attorney. Sometimes the banks will have to change what they're putting on the account. And whereas when it's held in the trust, then that account is owned by the trust, and you just have a clear document saying if the trustees are incapacitated, then the successor will step in and help take care of that. And so that's with regards to the finances, we found that trusts are just a better vehicle if someone becomes incapacitated. And then with regards to medical decisions, like I said, we do it for all of our estate plans, whether you do a will or a trust. The individual, you name individuals who step up to be able to make those medical decisions if you're unable to. And then a HIPAA release just authorizes individuals to be able to talk to your doctor about your care. It doesn't authorize them to make decisions. That's done with your powers of attorney. If those powers of attorneys are not set up, then individuals are left with default statutes, where and they're at the if those powers of attorneys are not set up, then you're left at the default statutes, and you're going to be relying upon the doctor or the agency to look at those and allow the individual to make choices on behalf of someone else. And if there's any confusion, if there's any fighting in the family and there's no powers of attorney, then sometimes you're having to look at a guardianship, which is a court process to get someone the authority to act and make medical and financial medical decisions for someone else as a guardianship, and conservatorship would be to make financial decisions. So having those powers of attorney in place prevents or helps us so that we often don't have to go get a guardian or conservatorship.
Yeah, so I was just going to add to that on regards to the checking accounts, financial institutions. Idaho recently, within the last couple of years, allowed for you to name a trust as a beneficiary of a financial account. Previously, that really wasn't something that you did. So now you're able to do that, which works great when you're wanting to transfer the assets at your death. But if you're looking at incapacity being a concern, you want to look at the fact that I need to have the trust be the owner of that account in order for the incapacity to work. If they're just the beneficiary of the account, that works great for the transfer at death, but doesn't really benefit you at the incapacity level. At that point, you would have to rely on the power of attorney to facilitate that.
Great stuff, guys. And let me ask you before we wrap here on this episode, and Tim, I'll start with you, and Alan, you can kind of piggyback as well. Can you share some client examples, obviously without getting too intricate into the details, but something that kind of illustrates for the audience how choosing that right structure between will and trust kind of made things smoother for the folks?
Yeah, I think looking at a family I'm recently helped, they essentially third marriage, they're looking at children beforehand. The kids felt like dad had everything set up as separate property. He left the accounts to them, had them named as beneficiaries of those accounts. What ended up inspiring was that the stepmom at the time decided that they weren't considered separate property and they were considered community property. And so by not having it structured correctly into a trust type situation, left it vulnerable for them to have a debate in court as far as, or at least have a debate outside of court before it got there to say, hey, this is considered separate property, therefore I should receive half of that, even though it, from documentation and the family's perspective, it was deemed to be separate property and go to the kids. So now you have the kids losing half of their inheritance because the fact that there was not a proper structure in place.
And Alan, for you?
Yeah, and so when I think about this question, I often think of families that have different dynamics. If they want to disinherit an individual, if you do not clearly set that out in a will or an estate plan, then the intestate laws would have them get it. And so I've had several situations where people did not do an estate plan, and then as a result, it went where the surviving people would not have anticipated that it would have gone. And on the flip side, when people do plan, when they set out clearly, these are my assets and this is where they go, then it provides a lot of clarity and a lot of direction for the family, such that it is what it is. It's set out in the document, and then it's just a matter of carrying that out. And so we love to help people plan and really just think through. Just yesterday, as a matter of fact, we had a couple that had lots of different decisions and just couldn't make a decision. And I was able to just walk them through and say, what are the realistic options that you have? And if you don't want those options, what are the options? And let's make a decision, because if you don't make a decision, then you're just going to leave it to chaos with the family. And we were able to spend that a little bit extra time that they needed to really help them make a decision and move forward to get that plan in place to bring clarity for their family.
Avoid that chaos for the family. It's very well said. Gents, thank you again for the time, the insights, and breaking this all down for the audience. I appreciate it, guys.
Thank you for having us, Mike.
That's it for today's episode of Law Potato, Hot Legal Topics with Idaho Values. If you want to learn more about wills, trust, or estate planning in the state of Idaho, you can find Alan and Tim over at aharrisonlaw.com. One more favor before you go for me. Hit like, hit subscribe, leave a review, comment, share the episode with someone who needs to hear it. I'm Mike Leon. We will see everybody next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.